There also I'm appealing.
Yes.
Yes. Also kindly come to page 22, prayer portion. What is the prayer in the writ application?
Yes.
Issue rule licensing, calling on the party to show cause as to why Rule 4 of the Odisha Group B, Group C, and Group D post repeal and special provision Rule 2022 shall not be declared otherwise. That was also the prayer in the first case, which I had argued. Then, if the opposite party do not show insufficient cause, make the rule absolute and issue a writ in nature of certiorari or any other writ or writs direction declaring the Rule 4 of Odisha Group B, C, and D post repeal special provision Rule 2022 as altered. Yes. Then para 5 and 6 important. Issue a writ in the nature of mandamus or any other writ or writs direction directing the opposite party to count the period of service rendered by the petitioner prior to their regularization by way of granting notional increment and other service benefit from the date of their contractual appointment. Then 6. And further, notification dated 13/4/2023, that is Annexure 20, and the standard operating procedure dated 22/6/2023 under Annexure 21 be quashed. In the first writ application when it was filed, only the Rule 2022 was published, but during the pendency of the writ application, this notification was made, SOP was made, and therefore we have challenged it in other writ application. In that writ application, the first writ application, we have filed an application for amendment that is still pending. So therefore, I am showing this is the prayer in the other writ application where we have also challenged the SOP. Now you'll also look to just kindly have a glance. Of course, that you'll also have seen yesterday, the repeal provision, that impugned provision, which are also annexed here. That is at page.
Mr. Rautray,
Yes.
are any other council going to address or they have nominated you? You will also address.
I am also there.
I think my learned senior has already completed.
No, he
So
says yes.
Page 129. Let's look to page 120. I have very limited, because so far the law is concerned, I have already prepared the compilation of the, I'll only give to your lordship. I have prepared a note also that will give it. And your lordship had also suggested to prepare the compilation of different resolution and rules. I've done it also for your lordship's convenience. They kindly come to page 129. This has been impugned. This is challenged. This is 16th October 2022. Lordship, get it?
Page
129. Annexure 19 in that writ application.
Which writ?
This writ application, that is WPC 22013 of 2023. 22013 of 2023.
yes.
Lordship, kindly come to definition that Rule 2, employees means person appointed under the
So
contractual.
You are at page 129,
Yes, ma'am. Yes, sir.
21303.
No, 22013. 22013.
22013. Sorry.
The prayer I had placed in that, where this SOP has been also challenged. This is a consequential SOP to the repeal rule. You also kindly come to page 129.
Yes.
This is that repeal provision Rule 4 has been challenged in this case. 16th October 2022, this notification. You also kindly see 2C. Employees means persons appointed under the contractual rules. That means 13 rules. Those persons appointed on 13 rules. Then D. Initial appointees means the persons appointed under the Odisha Group B post contractual appointment rule 2013 and the Odisha Group C and Group D post contractual appointment rule 13. The employees has been defined, those who are under the contractual rule 2013, and initial appointees means those persons were appointed under 2013 rules. And so far as we are concerned, as I have pointed to lordship, we are appointed in 2006, 2007. And prior to 2011, and we have completed 6 years of service. Our service has been regularized on completion of 6 years from that date. That is much before the rule came into force. Now, you also kindly come to Rule 4, Rule 3 and 4. It may be a little bit cost of repetition, but I'm drawing your lordship's attention to a particular portion which I had not placed emphatically. Rule 3, repeal. Save as otherwise provided in Rule 4, the Odisha Group B Post Contractual Appointment Rule 2013 and Odisha Group C and Group D Post Contractual Appointment Rule 13 is hereby repealed. Then special provision. The initial appointees appointed under the contractual rule now in position shall be deemed to have been appointed against the post on regular basis as on the date of the commencement of the rules. On such regular appointment, 2, under sub-rule 1, the pay of such employees shall be fixed by way of granting notional increment considering the date of their contractual appointment. That is from the date of initial appointment of contract. 3, the employees who have been regularly appointed in the service after completion of 6 years of service under the respective contractual rule shall be allowed for fixation of their pay as on the date of commencement of this rule by way of granting notional increment considering the date of their contractual appointment. Then 4, the employees whose service have been so regularized shall be allowed service benefit like promotion, etc. in the cadre on notional basis to which they would have been entitled as per rule had they been recruited on regular basis. Then the next page is important, page 131. On commencement of these rules, the employees shall be assigned seniority in the cadre to which they would have been entitled as per rules had been recruited on regular basis. That means from the date they were appointed pursuant to the 2013 rule, they will be construed to be a regular appointee from the initial date of their appointment for the purpose of promotion. This is the. Now you also kindly see, subsequent to this, they have issued at page 133. You also come to page 142. Page 142, which is impugned also. Annexure 20. Government of Odisha School and Mass Education Department, 13/4/2023.
Yes.
This notification was made pursuant to that impugned repeal rules 2022. The regularization of contractual initial appointed teachers. The treatment of regular service period regularization of teachers recruited before and after the notification. Before and after the notification of Odisha Group B Post Contractual Appointment Rule 2013, by notification number so and so dated 17/1/2014, vis-a-vis Odisha Group B C D Post Repeal and Special Provision Rule 2022, which is impugned here. The J and PG Department notification dated 16/10/2022 was under consideration of the government. Now, therefore, government pleased to consider the regular service period, regularization of such teachers joining on contractual mode, initial appointees as given below. 1, the regularization of these teachers, initial appointees, that has been defined under that repeal rule. Initial appointees appointed in accordance with the Odisha Group B Post Contractual Appointment Rule 2013 of J and PG Department will be considered as per Odisha Group B C D Post Repeal and Special Provision Rule 2022. Then 2, the regular service period of the teachers who have been appointed contractually prior to the notification. That's a kind market. The regular service periods of the teachers who have been appointed contractually prior to the notification of Group B Post Contractual Appointment Rule 2013 and have also completed 6 years of contractual service prior to the notification of the said 2013 rule will be counted on completion of 6 years of contractual service, and their seniority will be maintained as per their position in the merit list in the year of recruitment in accordance with the department resolution dated 25/7/2011. Then 3, the regular service period of the teacher who joined contractually prior to Odisha Group B post contractual appointment rule 2013 and have not completed 6 years of service prior to the notification of the said rule will be considered as per the department resolution dated 25/7/2011, which I had placed yesterday. However, irrespective of their date of regularization, they will be allowed 1, seniority as per the merit list of their year of recruitment and will continue to be senior the teachers recruited in some subsequent batches year of recruitment. 2, notional pay not less than teacher recruited as per Group B post contractual appointment rule 2013 of GA and PG department for the regularization of contractual teacher mentioned at paragraph 1 above corresponding to so and suppose observing ORB rules are being created. They not only they issued this notification, then subsequent, this is challenge, subsequently they issued this SOP that is at page 144. That starts from page 143 by the Government of Odisha School and Mass Education Annexure 21 on 22/6/2023. This was issued. And this is the SOP. This will be, you'll also look to this, the exactly how discrimination is being caused. Serious discrimination. Page 144. You'll also get it.
Yes.
Standard operating procedure for regularization of service and fixation of pay in respect of secondary school teachers under notification dated so and so. After commencement of the Odisha Group B, C, Group D post, repeal and special provision rules 2022, issued by notification number so and so dated 16/10/2022 of GA and PG department, which came into force from 17/10/2022. Government in the School and Mass Education Department, Odisha, has implemented the said rule in respect of government secondary teacher under their administrative control by notification dated 13/4/2023. Now, after careful consideration, the following modalities are defined for smooth implementation of the notification dated 13/4/2023. For those one capital A, they have categorized. For those teachers initially appointees, that means appointed under 2013 rule, joined in accordance with the Odisha Group B post contractual appointment rule 2013 and Odisha Group C and Group D post contractual appointment rule 2013, along with this department resolution dated 27/10/2014. The contract / initial appointee teachers shall be allowed fixation of their pay as on the date that is 17/10/2022, calculated notionally from the date of their joining by way of granting increment on completion of each year of service under normal circumstances. That means that will be counted from the date they are appointed, not 6 years, they appointed. Then 2, fixation of pay in the revised pay structure shall be made by the heads of the office, competent authority for Annexure A. Let's keep over. Then B, their other category. For those teachers who joined contractually prior to the commencement of the Odisha Group B post contractual appointment rule 2013 and Odisha Group C and Group D post contractual appointment rule 2013 and have not completed 6 years of service prior to the date of the first appointment of the contract / initially appointed teacher made as per the department resolution dated 27/10/2014. 1, date of regularization of service of such teacher will be revised antedated 2/4/2016, that is date of earliest joining of contractual / initial appointee teachers as per this department resolution dated 27/10/2014. Pause for a moment. Now what they have done, a person who has been appointed prior to 2013 but subsequent to 2011, suppose a person has been appointed in 2013 itself, the rule came into force in 2014, and he is completing the service of 6 years in 2019. So now what they have done it, so for that category of teacher, they are not coming under this 2022 rules, neither they are coming under 2013 rules, and ultimately they are not also coming under this repeal provision 2022. But what they have done, they have antedated their date of regularization to 2016. That means the date when for the first time the recruitees of 2013 were appointed. That means a person completed 19 years, 2019, because he has been appointed in 2013. Now they have antedated from 2019 to 2016, so far as that group is concerned. We are the person, we are the appointee of 2006-7, 2678 like this. And they are the appointee in between 2011 to 2013. They have made a group so far as this SOP is concerned, and they have extended this benefit to them. Then, sir, 2, seniority of such teacher. That means that B, category B, seniority of such teacher shall be as per the merit list in their year of recruitment and will continue to be senior to the teachers recruited in subsequent batches year of recruitment. 3, they shall be allowed for fixation of their pay as on date 17/2010/2022 by granting notional increments from the revised date of their regularization, that is 4/4/2016, that antedate 16. They said that they get all notional benefit, notional increment from the revised date of regularization, that is 4/4/2016. Even if they have completed 6 years in 2019, they have given this benefit. Then fixation of the pay revised pay structure shall be made by the head office. Then next, so far as we are concerned, what they have done, that is at page 145. Page 145. See, for those contractual initial appointed teachers who join in the service prior to the commencement of the Odisha Group B contractual appointment rules 2013 and Group C and Group D post contractual rule 2013 and date of regularization their service falls prior to the first appointment of the contract initial appointed teacher made as per the department resolution dated 27/10/2014. 1. Service of such teachers shall be counted on completion of 6 years of contractual service, and their seniority will maintain as per their position in the merit list in the year of recruitment. So far as we are concerned, on completion of 6 years, our service has been regular, we will get the benefit. But the category B is concerned, they have antedated to 2016. They made it matched with the persons, those are recruitment of 2000 subsequent to 2013. So far 2013 is concerned, they have given all benefit right from the date of initial engagement, initial appointment. And you also look to the illustration B, that is there also.
Mr. Rautre, one thing, why have they used the different words in B and C?
Because they have categorized teachers.
B, they have used teachers,
Yes.
and C, they have used contractual/initial appointee teachers.
Yes.
Why have they used that?
Same. That is also same. Same.
All are group B. There is no dispute about that.
There is no dispute that group B. They all are group B. Their qualification is same. The recruitment process is same. The post they are holding same. The status of the institution are same. Secondary schools. There is absolutely no difference.
Scale of pay.
Scale.
Category initial appointment.
You also category A. You also look to category A also. My Lord Justice, Madam Roth has asked that question. You also look to also category A. Page 144. The contract /initial appointed teachers. Same thing. They have used the same word.
Not the same thing. That initial appointee is not used in that B.
Initial appointment.
So far, the initial appointee has been defined under that 2022. 22. That repeal provision. Also look again. You also look again.
2D.
Rule 2D.
2D.
Yes.
2D.
Page 129. Initially appointment means the persons appointed under the Odisha Group B.
2013, both.
That's it. Though they have used so far a group category A is concerned, initial appointment, all like that is in terms of that rule they have said. But so far as the category B and category C, as you also rightly pointed out, they have used that word also. That is they have used. So my respectful submission is that is you also kindly look to the illustration. My friend is correct.
No, forget illustration. Let us see the C again.
Yes, sir. See again.
There are three classes.
Yes, sir.
One, appointed on contractual basis in terms of 2013 rule. Two, those who were appointed prior to 2013 but completed 6 years after 2013. Three, those persons who were appointed prior to 2013 and completed 6 years before 2013. All right.
Right.
So C deals with that.
Right.
Now let us see
Again.
of C.
Yes, sir. Because we must at least come back. For those, see, at page 145. for those contractual initial appointed teachers who joined in the service prior to the commencement of Odisha Group B post contractual appointment rules 2013 and Odisha Group C and Group D post contractual appointment rule 2013 and the date of their regularization of their service falls prior to the first appointment of the contract of the initial appointed teachers made as per the department resolution dated 27/10/2014.
That is 2013 rule.
13.
No.
Right.
Should have the first advertisement.
Yes, pursuant to that 13 rule, they have made an advertisement on 27/10/2014.
Therefore, these are the persons who completed 6 years prior to 2016.
Right.
When the first
Right.
appointment was made.
Yes, sir.
When the first appointment was made under 2013. Yes.
Their first appointment was made in 14. First appointment was made in 2016.
This is what we are saying.
Yes.
First appointment was made in the year 2016.
Right.
Group C is class of such contractual teachers
Yes.
who completed 6 years prior to that.
Right.
So and the date of regularization of their service means when they complete 6 years.
6 years.
Falls prior to first appointment
Right.
of contracts less initial appointed teachers made as per
As per
resolution
the
dated.
advertisement dated 27/10.
So that is in 2016.
Right.
All right.
Yes.
So this is
This is
and
there.
then what is the provision for them?
Nothing.
No,
Nothing.
let us see.
Yes. I'm sorry. Yes. One, service of such teachers shall be counted on completion of 6 years of contractual service and their seniority will be maintained as per the position in the merit list in the year of recruitment. But our service shall be counted only on completion of 6 years. Whereas so far as they are concerned,
No, you are a class who completed 6 years prior to the persons appointed in 2016 and the persons who completed 6 years after 2016 by antedating they have been given seniority.
Yes.
But you are the persons who had completed 6 years prior to 2016.
Right. Yes.
Therefore, this is special provision for you. That completion of 6 years of contractual service and their seniority will be maintained as per their position in the merit list in the year of recruitment.
Year of recruitment, suppose we have been recruited the year 2006, amongst ourselves, that is the seniority that will maintain. But we are not.
How do you say that you are going to be placed below 2016?
Sir, I'm not. That is not my case. That is not my case. My case is you have given the benefit of that 6 years.
Yes.
In respect of those appointees, treating them as initial appointees either under 2013 rule or the category of B teachers, those who have been appointed prior to 2013.
No, what benefit has been given to them, which benefit has not been given to you?
That so far as the increment is concerned, if the period of service should be counted from the initial date, that means a person has been appointed in 2016.
All right. So whether there is any class of person who has been given any benefit prior to 2016,
No.
before 2016,
No.
whatever benefit has been given,
Yes.
has been given in accordance with 2013 rules.
Yes.
And applying 2013 rules, first appointments were made in 2016.
Right.
So therefore, for those who were appointed under the 2013 rules, those who were appointed before 2013 but completed 6 years after 2016, they have been.
My entire submission before RCB is if they are holder of the same post and their appointments were made also in the same manner, then how can they make a discrimination between?
How are they? This is what we are trying to.
What I will
understand.
explain. I'll explain. Let me.
We must have
That's correct.
failed to find out what is the.
Yes, sir. Yes.
So what is the disadvantage?
Disadvantage is this, Mirat. The period of service of 6 years which will be counted so far as those persons are concerned, those who are appointed subsequent to 2013 or immediately prior to 2013, they will get the benefit of that period of 6 years, which were on contractual basis. Whereas we, the persons,
No, they are not getting benefit of 6 years.
Yes, sir.
They are, see, some of them may be getting benefit of 1 year.
No,
Some of them.
no,
may be
no, no,
getting-
no. If you, that is, you also look again. They are, as a whole, you also look to page 144. Page 144.
ସମସ୍ତେ 6 ବର୍ଷ ପାଇବେ।
ପାଇବେ ନା, ସମସ୍ତେ ପାଇବେ ନା, ସମସ୍ତେ ପାଇବେ।
Milord, let me, can I, Milord, be?
Just for a moment.
Let him
please,
come, let him.
Acharya,
come,
please.
Acharya.
Also, look to page 144.
Yes.
This is a group A.
Yes.
The contract oblique initial appointee teachers shall be allowed fixation of their pay as on 17/10/2022, calculated notionally from the date of their joining by way of granting increments on completion of each year of service under normal circumstances.
So you want that the period which you spent
Right.
should also be
That is
computed
exactly, yes.
for the purpose of grant of increment.
That
This is your
that
whole
is right.
point.
The category
Let us-
Bs are not initial
And
appointees.
so far the category B is concerned, they are not the initial appointees under 2013 rule,
No, they are not.
but they have been given a benefit.
All right.
That's it. That's it. I think you also, I communicated to you also. Then I need not, because Mr. Acharya is definitely will argue. Sorry. I have prepared a note for your lordships. I have also judgment, the note that compilation of the rules and the circulars which you also wanted, that I can give to your
whatever.
lordship. Let the state council argue the matter, then I'll give it in my reply. That's all. That is my entire case.
We will grant you some time to
Yes.
reply.
Yes, ma'am.
Yes, Mr. Acharya, anything?
No, Milord, 2 more points, let me just clarify. On facts, I think my lord is now clear. Milord, in 2003, I think these 2 resolutions might not have been shown to you, lordship. Milord, 2003, because of the dearth of teachers in the states, in the secondary school level, so the government decided by virtue of a resolution to make appointments. That is the basic resolution which came to be published in 2003. And the recruitment, Milord, as per, if your lordship would permit me, I will take your lordship. This is edit petition number 36039 of 2023. Milord, serial wise, I cannot say because that would be in the 5th page. 36039 of 2023. Milord, there is a thinner distinction. That is what, Milord, that is why, Milord, I request your lordship. 36039.
Yes.
Milord, your lordship may kindly turn to page 23 of the brief.
Page 23.
Page 23, Milord.
Yes.
Milord, the opening words, your lordship may kindly, if your lordship would permit me, I will just read it. The vacancy
This was
position,
This was placed.
this was placed. So your lordship may kindly look at, in view of the gravity, the 3rd paragraph. Gravity of the situation, and after careful consideration, government have been pleased to engage qualified teachers on contract basis in different government high schools, old and new, with the following terms and conditions. Milord, these are the educational qualification. Your lordship may kindly turn to page 24. Milord, clause E, lordship got it, Milord.
Yes.
The B.Ed candidates would have registered their names either in special employment exchange located at so and so. That means, Milord, they are all registered B.Ed candidates qualified to be appointed as teachers. Milord, this selection procedure, if your lordship would look at the last 2 paragraphs, the Director Secondary Education would bring out an advertisement indicating the post to be filled up in each circle and invite applications circle wise to be filled before the to be filed before the respective inspectors of schools. Residential certificate shall be submitted by the candidates as proof of so and so so and so. That means, my lord, the process of recruitment was also transparent by inviting applications through open advertisement for the purpose of recruitment of the teachers. Fulfillment of educational qualification as is required to be validly appointed as a teacher, and this selection process was also through a transparent method. Your Lordship may kindly look at the last page. This may not be relevant. The next resolution Your Lordship may kindly turn to, that is in 2008 at page 77 of the brief.
Yes.
This resolution, because those teachers had, prior to that 2008 at page 75, page 75, annexure 6.
Yes.
By virtue of this resolution in 2008, all those teachers came to be appointed from 2004 onwards. 3 onwards, I'm sorry, 3 onwards. So by the time there was a demand for regularization because they were not given the incentives which were given to the other similarly situated teachers. So the government came out with this resolution in 2008, 75 page your lordship would find that the contractual, Milord, your lordship may kindly may I read it, Milord?
Yes.
The contractual engagement of teachers on contractual basis in different government high schools of the state has been made since 2003 and 04 onwards by abolishing an equal number of scale bearing posts as per the Finance Department Resolution number so and so 38/2004 so and so odd, the last being 2006, taking into account the career advancement needs of the contract teachers. Government, after careful consideration, have been pleased to take the following decision in order to give career advancement benefits to the teachers engaged on contractual basis. 1. The contractual teachers so engaged will be regularized in their respective posts only after completion of minimum 6 years of service. The 2013 rule provided similar kind of provisions, which has been since repealed in 2002 by the repeal rule. I'll come to that in 2022, Milord. So of minimum 6 years of continuous and satisfactory engagement, after regularization, they will be eligible for all service benefits as applicable and admissible to regular government employees of the state. That means, Milord, after completion of 6 years of service, their deemed date of regularization would be falling after completion of 6 years. Suppose, Milord, a 2003 appointee would be deemed to be regularized with effect from 2009. But by virtue of this 2022 repeal and special provision rule, what they have done, they, Milord, suppose a 21 appointee, your lordship was putting a pertinent question. A 21 appointee, Milord, who was appointed just 1 year prior to the commencement of the repeal rule would be deemed to be regularized from 2021 itself. There is the discrimination. But am I clear? These 6 years, Milord, what they said, 13-14 rule they have repealed. By virtue of the rule, the teachers who came to be appointed, they say that that rule has been repealed. The very recruitment rule, Milord, which provided for the regularization of those class of contractual teachers after completion of 6 years of service, they say that rule is no more applicable, that is obsolete and that is repealed. But I fail to understand. There is also a serious anomaly. I will explain that. But the basic legal concept which I intend to pursue before your lordship, that they are trying to create a class within the class. These similarly circumstanced teachers, those who fulfill the eligibility criteria and have come through a particular selection process, 13 appointees are contractual. Post 13 Milord recruitment rule, this contractual appointment rule, and by virtue of the 2003 resolution of the government, which has also the force of a statutory order, because those rules they framed in exercise of power under 309, and those are the statutory notifications in regular conduct of government business. So therefore, the exigencies of work, Milord, to cater to the educational needs of the state, they felt it expedient, and accordingly these appointments came to be made on contractual basis, since regular recruitment could not be conducted following the procedure under the staff selection rules. There is a statutory recruitment, and the staff selection commission is authorized to conduct the regular recruitment of all those Group B and Group C posts. Your Lordship was posing another question. Group B and Group C teacher posts are on the basis of the qualification, Milord. Suppose Matric CT, ISCT, BA, BD, like this, Milord. So that is not so far the categorization under this statutory resolution and the contractual rule is concerned. There are two categories of posts, they say. Category Group B and Group C. Milord, that categorization your Lordship would not find either from the resolution which I just now read out, nor from the 2013 or the 14 contractual regularization rules, appointment and regularization rules. Your Lordship may kindly now come to, after this 2008 resolution by which they decided to regularize the contractual teachers after completion of 6 years of service, they came out with another resolution in 2011 that your Lordship would find at page 77, annexure 7 to the writ petition. Lordship may kindly turn to that. Regularization of services, the subject of which was regularization of services of teachers engaged in high schools on contractual basis. The state government, as part of austerity measures, adopted contractual mode engagement of personnel with payment of each sum per month as consolidated remuneration. The government in school and mass education department decided to engage contract teachers in government high schools, creating such posts on abolition of vacant regular scale bearing posts. There were in the staffing pattern or these sanction strain, there were regular teachers, those who were carrying the regular scale of pay. They did not want to fill up those posts. They wanted to exploit the services of the qualified teachers on the basis of this contractual mode. So the contract teachers, those who came to be appointed with consolidated salary or remuneration, the government as a policy decision decided to regularize them. Regularization after completion of 6 years, both contemplated under the 2008 read with this 2011 resolution, and also subsequently which came to force by virtue of this 2013 and 14 rules. This is not a statutory rule, Milord. They say this is statutory notification. But by virtue of 309 rule which they promulgated, that is in 2013 and 14. So this 2011 resolution essentially, Milord, also postulated the same thing, regularization after 6 years of service, and the dim date of regularization would be after completion of 6 years. By virtue of this rule 4 of the special provision rules 2022, Milord, what they have essentially done, they treat those appointees after post 2013 contractual appointment rules which came to be repealed by this 2022 rule from the respective date of their initial appointment. That means the teachers, those who have been appointed between 2016 to 2022, irrespective of their, there is the discrimination. Am I clear? Suppose a 2020 appointee would be deemed to be regularized from 2020, whereas a pre-2013 appointee or pre-2013 appointee, those who have already rendered considerable length of service, after completion of 6 years, they will be entitled to the same benefit. That means the 6 years of service would essentially not be counted for the purpose of pay, seniority, increment, and other consequential service benefits. That is how this special provision repeal rule is patently arbitrary and discriminatory. So there, my lord, comes the treating the equals as unequals theory. That I have formulated a date chart along with this synopsis, list of dates and the citations which I propose to cite upon, rely upon. Lord, your lordship may, Lord, this I think I have passed on this too. Lord, your lordship may kindly four judgments are up for this purpose. These are all oft-quoted judgments. Dev Gupta, a recent judgment which I have given versus PC University of Technology and others. 2023 judgment, Lord, at page 10 of the, Lord, I think factually I need not elucidate anything because this 2013 and 14 contractual etc. rule and the 2022 special provision rule have been exhaustively cited before your lordship. So I need not repeat, that would be wastage of your lordship's precious time. Lord, this Dev Gupta case, which Lord, a 2023 recent judgment, relevant para I have just given. If your lordship would require me, I can file the entire judgment, photocopy of the judgments. Lord, para, it is now well entrenched in our constitutional jurisprudence that the doctrine of equality has varied and layered dimensions, one of which is that Article 14, equals must be treated equally, unequals must not be treated equally. What constitutes reasonable classification must depend upon the facts of each case, the context provided by the statute, the existence of intelligible differentia, which has led to the grouping of the persons or things as a class, and the leaving out of those who do not share the intelligible differentia. I mean, let us say, well, acknowledged legal principle, so I need not repeat it. So, the question is, had there been different, they have not treated the equals as unequals as equals. What they essentially do, the teachers, those who came to be appointed between 16 to 2022, the 6 years, earlier by following the 13 recruitment rule, contractual recruitment rule, in all fairness, they should have been deemed to be regularized after completion of 6 years of service. They wanted to do away with the 13 rule, and by virtue of 2022 rule, they say that they would be treated as regular, deemed to be regular from the respective date of their initial appointment, irrespective of whether they have completed 6 years of service or not. So in our case, they say that you become regular after 6 years of service. In others' case, post 2016 appointee, they say that from the date of their initial appointment, they would be regular. So, the earlier appointees essentially, would be treated. So far, the pay and other aspect, though the seniority has been protected, they say, in order of their merit in their respective year of recruitment. Suppose in 2003, there is a merit panel because they follow the advertisement procedure, call for the candidates, and by following the process of this selection, they recruit. They make the selection and recruitment. So they say that in order of our merit assigned to individual teachers in the respective merit list of the year, our seniority would be protected. But so far the pay, emoluments, seniority and other aspects are concerned, the latter appointees between 16 and 2022 would be placed above us so far the pay is concerned. So there cannot be parity of pay. So a teacher who is essentially some of them are our students, because 2013 teacher, when in 2022 19 years of service, some of them were our students in class 8, 9 and 10. They now become senior to us by virtue of this repeal rule of 2022. So there the disparity comes. So the discrimination is that breeds discrimination, and the inequality clause, which is essentially forbidden within the framework of scheme of Article 14 of the Constitution. So this thereafter, the second judgment, is a very well discussed. I have given. I need not take your lordship's time. It's all crystallized. Then the number 2 judgment is Budan Chaudhary, the famous case of 1955, Article 14 that deals with forbids class discrimination. It's a oft-quoted judgment. I need not read it. Lord, now your lordship may kindly look Prohari case versus State of UP 2018 SSC at page 14. Your lordship would find it. If your lordship would permit only the other para 32, I will just place. The more dynamic version came 2 decades later in EP Raipa, wherein Bhagwati J expanded the scope of Article 14 of the Constitution of India in the following terms. From a positivistic point of view, equality is antithetic to arbitrariness. In fact, equality and arbitrariness are sworn enemies. One belongs to the rule of law in a republic, while the other to the whim and caprice of an absolute monarch. Where an act is arbitrary, it is implicit in it, and it is unequal both according to political logic and constitutional law, and is therefore violative of Article 14. And if it affects any matter relating to public employment, this is important, public employment, it is also violative of Article 16. So I am on that. So it is basically, a gross infringement of both Article 14 read with Article 16 because it concerns public employment. So, Article 14 and 16 strike at arbitrariness in state action and ensure fairness and equality of treatment. They require the state action must be based on valid relevant principles applicable alike to all similarly situated, and it must not be guided by any extraneous or irrelevant considerations, because that would be denial of equality. Where the operative reason for the state action, as distinguished from motive inducing from the antechamber of the mind, is not legitimate and relevant, but is extraneous and outside the area of permissible considerations, it would amount to malified exercise of power, and that is hid by Article 14 and 16. So, anything, that is tainted with malified and arbitrariness strikes at the root of Article 14 and cannot thus be sustained in the eye of law. So, your lordship may, this is all discussed here, so I need not go through the fourth case. The principle here is that so long as two employees are a part of the same cadre, they cannot be treated differently. Here all are teachers, recruited following the same process of advertisement and all. 13 contractual appointment, etc. rules, they prognosticate the same kind of selection, whereas the 2003 government resolution also contemplates the similar method of selection with similar type of eligibility criteria. So therefore, if they belong to the same cadre, there cannot be differential treatment and they cannot be treated differently. That is what this Union of India Atul Shukla case says. May I read it? It is not necessary, So, the fifth case, that classification way of cut-off date must be found on an intelligible differentia and must have reasonable nexus with the object sought to be achieved.
No.
So sought to be achieved. So there is no reasonable classification. There is what is the object sought to be achieved is also not spelled out in 2022. They simply say in a most arbitrary manner that they would be deemed to be regular from the respective date of their initial appointment. The date of their, that means, which means, I gave an example, 21 appointee would be regularized from 21, 20 appointee would be deemed to be regular from 20, whereas a 2004 appointee would be regularized with effect from 2010, and not with the pay protection, etc., which have been guaranteed to the post-2016 appointees who are protected by virtue of a repeal rule. They say it is a repeal rule. The basic object of the 2022 rule is to repeal a particular recruitment rule which provided safeguard to the contractual employees for the purpose of regularization. By virtue of a repeal rule, they confer certain additional and extra benefit to the same class of teachers within the same cadre in order to confer seniority from the respective date of their appointments, whereas we are being treated after 6 years, I am repeating. So therefore, Lord, my humble submission is that the similarly circumstanced employees or the teachers, which we may say those who are, my lord, discharging a very noble function in the society. I do not know. It's a hitherto unknown concept. My lord, I was, when in the college days, I remember that we were quoting in a union function, one of the very noted politicians of the state was the Dr. Hari Krishna Mahatab. He was as the president of the students union, I said that, Lord, there is a slogan in Soviet Russia that the tallest building in the city should be an educational institution, and no building in Moscow town should be taller than the Moscow University building. This is what this slogan in Soviet Russia was in those days. So here, my lord, first of all, you exploit the services of the members of a noble profession, those who guide the future conscience of the entire nation. You take their services, utilize their services, and then subject them to class discrimination, which is essentially, my lord, not known to the concept of equality and non-arbitrariness. So therefore, my lord, I need not elucidate further. Let the state respond. What is the nexus with this 2022 rule for the purpose of objecting for the achieving the object, which has a reasonableness nexus with the philosophy as propounded by them in the 2022. Lord, I am deeply obliged. Lord, all those factual aspects have already been discussed. I need not repeat. So the question of law, I have already crystallized by shape of this written note of submission with all relevant provisions, the statutory notifications beginning from 2003 until the promulgation of this 2022 rule. Lord, I am deeply obliged.
Lord, what remains for me? Okay. What remains? Something remains which I'll quickly tell my lord. Quickly, very quickly. I'll not take my lord's time, but very quickly I'll confine myself to the left out points only. If, as per me, some Lord, I will confine myself. Where is the discrimination? My learned senior Mr. Reiteration has said, with regard to sanction of pay and with regard to non-counting of service, not the question of seniority. The reason being, your Lordship has already seen 2003 policy. Lordship has already seen 2005 policy. I represent the category of teachers, those who have been appointed pursuant to 2003 and 2005 policy. I did not take my lords in detail to those resolutions. Those resolutions are akin to these 2013 rules. They provide the similar procedure for appointment of these petitioners. ORB Act and other things have been followed. Now today, we have been regularized since 2011, 12, 13, 14. Those are the period of our regularization. So in any view of the matter, we continue to be the seniors all throughout. We don't lose our seniority. Am I clear, ma'am?
Yes, and I don't think that any of these
Yes.
reasons
So let there be no confusion.
deny you seniority.
Right, my lord. Let there be no confusion that we are losing our seniority. But what we are losing is this calculation of pay, which in terms of this 2022 rules is given in favor of the similar category of employees from the date of their initial appointment. Whereas we are given on completion of 6 years. Am I clear, man? That it is already said, and I'll just clarify that and complete my submission. Below I will cite 2-3 judgments. That's all. Now, your lordship has seen there are 3 categories of teachers. 1, teachers appointed prior to 2011. I deliberately, I consciously say prior to 2011, they form one category. One more category of teachers appointed 2011 to 2013. That is, 2013 rules come into force. They form the second category. Third category, this appointed in terms of 2013 rules. So what they have done is, pursuant to 2013 rules, that 4/4/2016 cutoff date they have taken. If your lordship sees that 2022 rules, what they have done is, 22 rules did not provide any provision for us. If your lordship kindly see that, because let there be no confusion on that. 22 rules, regularization and service benefit, did not make any provision for us. Kindly see that.
No, whether 2013 rules made any provision for you.
No, not at all.
So therefore, when they were repealing
Obviously,
2013,
has to be, cannot be, my lord, that's just very correct. Now, our grievance came into force, that 2023 notification and the SOP 2022, which they have formulated and they have made three categories. That SOP, that provided the discrimination. In what way they have given it for, see, only for that limited purpose, 2022 rules. Page 161 of my brief. This is WPC 7715 of 2020. Rather, it is at page 162. I'm sorry, Lord, we will be taking pain to turn over this.
yes,
162, Lordship has seen the special provision. The initial appointee is appointed under contractual rules now in position shall be deemed to have been appointed against the post on regular basis as on the date of commencement of these rules. 2. On such regular appointment under sub-rule 1, pay of such employees shall be fixed by way of granting notional increment considering the date of their contractual appointment. Meaning thereby that the whole fixation of pay relates back to the date of their initial appointment. The next is
the question may arise.
Yes.
That you do not have the locus standi to question the validity of 2022.
Absolutely.
Because
Yes. Till that 22 SOP comes into force.
SOP you may be aggrieved by that.
Yes.
Because that deals with
Lordships are very
not only
correct.
2013,
Absolutely. I deeply oblige. I am grateful. The Lordships are correct. That is what also came to my mind when I was preparing the matter. That came to my mind. So where is that provision for us in this 2022 rules? Apparently, on the face of rules, there is nothing.
there should not have been anything.
Because 2013 did not provide anything for
Because
us.
2013 was
Correct, my Lord. Correct. We are the categories who are appointed pursuant to the resolution of 2003 and 2005, regularized at different points of time, either 2011, 12. I have given a chart of that also in my brief. A chart of our, I have given that. If your Lordship kindly permit that, I can show that to you, my Lords below. That is at page 66 of my brief.
well, if we hold 2022
Right. Lordships are correct.
repeal invalid, then that will prejudice the cases of those who,
Obviously. Yes,
who,
yes.
who have been given advantage. Who have
Yes. Correct.
been, who have
Lordships
been
are correct.
benefited by that.
So that's the reason I am trying to show, my Lords, that specific provision. Kindly see, my Lord, page 162. Really, you are agreed by that SOP, which is formulated with help of these rules. That's the reason we are before my Lord's. See, my Lord,
No,
on
they have not, that SOP is not this thing, to enforce 2013 rules or whatever.
that is, my
The
Lord.
SOP is in the light of the resolutions, 2013 rules and subsequent repeal.
That your Lordship may kindly see from page 87. That only in terms of 2022 rules, they first issued a notification. Then with help of that notification, they brought out this issue.
No, with the help of notice, even if they say,
That for your Lordship to consider, my Lord.
if it is said in the resolution that is in the light of.
Yes,
the
that is
repeal,
needs a
but that means that it is in the light of, yes, repeal.
yes.
Repeal of 2013
13.
and then the existing teachers,
22.
how all of them are to be treated.
Right.
In that background, the resolution.
But I just saw your Lordship page 187. Lord. To rule out that kind of possibility, kindly turn to page 187. Kindly see me.
Please.
I mean, the treatment of regular service period, regularization of teachers recruited before and after notification of Odisha Group B post contractual appointment rules 2013 by notification number so and so dated 17/1/2014, GA and PG department vis-a-vis Odisha Group B, C and D posts repeal and special provisions rules 2022 by GA and PG department notification number so and so dated 16/2022 was under consideration of the government. Now therefore, the government is pleased to consider
the regular service period, regularization of such teachers joining on contractual mode, initial appointees as given below. These three categories, para 1, 2, and 3. The first is the employees appointed in terms of 2013 rules. The second is group 2011 to 13, as I said to my lords. I'm sorry, Lord. The second is employees appointed prior to 2011. Third is 11 to 13. Now, on reading of this
According to you, there are three classes.
right, my lord.
One, who were appointed before 2011, under
Correct, my lord.
2005.
Correct.
Two, those who were appointed after 2011, but before 2013.
13.
So these persons appointed in 2011 completed 6 years in 2016,
16, 17. Right.
Their cases have been taken care of, by,
Absolutely correct. I'm grateful, my lord.
because you were already in regular service.
Service.
As on the date of coming into force
These
of
rules.
2013.
Correct.
Your cases have not been mentioned there, because 2013 is for the purpose of recruitment
Absolutely.
on contractual.
Yes, my lord. We have got it.
And subsequently in 2022, they repeat.
Yes.
Therefore, so
We are not
your
dealt with.
your three classifications
Yes.
are in this way. Their classification is in a different.
It is for the first time they are dealing with us in 2023.
Yes.
Yes.
They are dealing with you in the SOP.
Yes.
How are you to be dealt with?
Right.
Now, just think of a situation.
Yes.
Just think of this.
Right.
Had they not be, your case has been not dealt with by them in 2023.
23.
Just think of
Yes. Yes.
that you were just excluded because they were dealing with repeal of 2022 and 2013.
Yes.
So what would happen in this situation?
I'll tell you. I'll now tell you, Lordship. Now, these three categories, jointly
But
form.
these three categories. Suppose had there been no classification as seen in the SOP.
Yes. Yes. That we would have a different cause of action then. We would have a different cause of action.
So your cause of action arises because you have been included.
Yes.
No. Your cause of action arises
Very
because
correct.
certain persons have been given benefit.
Not only included, but in the same SOP, you gave benefit of calculating scale of pay from the initial appointment, that 6 years benefit, whereas we are not.
All right.
So I think I am now clear before my
Yes.
lord. To the extent of
Yes. Yes.
now, my lord, I'll be citing only 3 judgments, my lord. I'll not read. I'll just give my lord.
May I add only one? Lord, by virtue of lordship is my lord. Lord, by virtue of this special provision, they confer certain benefits, my lord, which are not, my lord, in conformity the benefit which have been given to us earlier. So therefore, the conferment of the additional benefit to the latter appointee, my lord, that breeds discrimination.
All right. Let him complete.
Yes.
Right. Lord, this only 3 judgments, my lord. Lord, the first judgment, Lordship could see page 11, running page 11 of this citation. Lord,
Yes.
para 15. Lord, with regard to all violation of Article 14, treating unequals as equals and equals as unequals.
Yes.
They are all on the same point. Your Lordship has already heard from my learned friend, Mr. Acharya. Then I did not place all the judgments and take time. I am relying on this para 15. The second judgment, Lord, this is DS Nakaram, Lord. This is
Yes.
well-known judgment.
Yes.
Then the second judgment is, I'll be relying on this page 61 or in page 32, or paragraph 32. I think I did not read all these.
Yes, that's not required.
Right, para 32 and 33 of the second judgment. This is that Kalikurchi Taluk. 2013 2SS. That starts from page 34, man.
Yes.
Now, my third judgment, I'll be relying on this an order passed by the now Supreme Court, only 2-page order, page 72 onwards. Basically, on the same point, the equality is the hallmark of administration of justice. That will be the point in all these 3 judgments.
Yes.
I think I have so grateful
Thank you.
before my.
Yes.
One more writ application that is a bit different, because my learned seniors placed about the counting of service period. So for this case is concerned, it is about seniority, which your lordship was asking, that is 26805 of 23.
I take permission.
What do you want?
26805 of 23. Your lordship may kindly see page 53 for a moment.
Seniority has been affected.
Yes.
How?
Yes, your lordship. As per the 22 repeal rules, rule for special provisions, rule 4.5 says on commencement of these rules.
Is there any seniority?
Yes.
Is there any gradation?
Yes, because these category of petitioners, they are working as teacher educators in District Institute of Education Training under the School and Mass Education. They are working as teacher educators. They were appointed in the year 2015 on regular basis. In the same year, another set of teacher educators were appointed on contractual basis. Your lordship may kindly see page 38 for a moment.
No, but whether your case is anyhow.
Yes,
connected
because
with
in year
2000
2021, I was above the contractual employees, and in subsequently on 11/10/22, a tentative a provisional gradation list was published, whereby I was senior to the private opposite parties. That was on 11/10/22. On 16/10/22, the 2022 repeal rules came into force, and in the month of November
Then
2000,
you will have to include all of them as
I
well.
have already implemented
How many?
all the my lord. Your lordship, 4 of them.
Only 4 of them are where.
I have some in representative capacity, 4 of them I'm implemented.
So how many persons?
There are about 13 to 14 persons.
Then that will be heard separately. Mostly. This one, okay. What is your case number?
WPC number 26805.
With this matter be. Listed separately. The separately issued notice. Yes. 1 week, 8 weeks. Yes. You wanted to say something?
No, let the state respond. It would be better in reply. We can answer all those queries. So, but Mr. Kuntia, I think, was taking some accommodation in the first hour.
Yes, when?
Monday.
Monday.
No, Monday, Milad, I have difficulty. Monday, I may not be here.
What do you
Milad,
want?
can it be?
Wednesday?
Yes, man. Any day next week.
Wednesday is a holiday, I think.
Thursday then.
17th.
Thursday
Then
you'll have enough
18th,
time to
18th.
prepare.
Tuesday, you can fix it to Tuesday.
Tuesday.
Hello.
16.
16.
16. You're at the same time, 2 p.m. Deeply placed.
Item number 11.
Item 11 was listed yesterday. My lord, your lordship wanted to know which was the leading matter. I've given.
May I be pardoned for a minute? May I be pardoned to mention a matter for a minute? Item 59, the other day your lordship wanted to take it up at noon here, but there is no noting today.
What is that matter about?
That is that gate matter, my lord, if your lordship remembers me.
My lord has fixed it to today, and the lordship has directed to make a mention that the date will be, a time will be fixed on another date.
Who is appearing for the other side?
I am for the state, my lord, senior is appearing, and Mr. Rautrai, Lord,
Rautrai in another case.
lordship may fix any date 1 week after, because appointment of engineers have been installed by the states.
So we can take up on the same day?
On both,
Huh?
on
16.
Thursday, if next Thursday, 2 days, so that I will argue. my
All
lord.
right,
One matter on Thursday, one matter on,
18,
my lord,
18,
18.
It is all right. It will not be taken up today.
18th it will be taken.
Today,
18th at 2 p.m.
18 2 p.m.
18 may not have difficulty. 15th.
No, 15th more eta rahigala pa 15th 16th 15th I have not
16th.
15th I have no objection for 15th.
15th will have.
15th already cases are fixed at 2.
18th another matter is specially.
Then
We
next-
can take up it on
22nd
22nd.
2 p.m. ମୁଁ ତ ଚାହୁଁଛି ହବ କିନ୍ତୁ ମଙ୍ଗଳବାର ଦିନ ଦିଟା ମ୍ୟାଟର କରିପାରିବିନି ଏକ୍ସଚେଞ୍ଜ
22nd, what is
They are
the?
proceeding with the selection process. It will, well, that your lordship has heard initially, rule 6 and 7 are on the dispute. Rule 6 previously rules provided that the selection would be done from amongst the graduate engineers who are eligibility criteria. By way of written statement, written test and
So we will take up, we will hear you on Monday.
Monday.
With the
Progress.
first 5 cases in the morning.
Yeah.
We'll see what can be.
Well,
Monday. First hour,
Yes. Monday within first 5 cases.
yes.
Very good.
Item 11.
Item 11, yesterday, my lord, the matter was listed, my lord. The lordship wanted to know the leading matter. Learned senior has got the instruction, my lord.
There are around 5 to 6 matters where counter affidavits have been filed. So your lordship may list this matter along with those cases on any date next week or the week after.
So it's just matter, so either of the along with so and so, which are said to be involving identical legal issues. On 2 weeks.
2 weeks, my lord. So you can file a reply, my lord, to that.
Item 12.
Obliged, my lord.
Well, my lord. This is a case, my lord, in short, I am just pressing, my lord. In 1925, one Kanaklata has gifted a deed, my lord, in favor of a committee, my lord, after her death, my lord. After her death, my lord, a committee constituted and discharged the duty, my lord. In 1945, same committee, my lord, has executed another deed, my lord, in favor of the school, my lord, which was subsequently the school was taken up by the second, my lord. RR was also.
What is your prayer?
My prayer, your lordship.
This is public interest litigation.
Lordship.
So what is the public interest?
But I am the former student. It is school property, my lord. It is anyhow. It is left out, my lord. It has not coming to the school. There is a hostel, my lord, earlier. Now the record to be corrected on request of the government, my lord.
Just let us understand. This is PIL.
Lordship.
What is public interest? What is the public interest involved?
Involved, let's say, earlier there is a hostel in same self-shoot land, my lord. Case with the same self the land property, my lord. Till 1998, the school was occupied. School was paying the rent, my lord. In 1999, there is an appeal, my lord, where the settlement officer reversed the order, my lord. By virtue of that order, one case Surya came to picture. Since 2000, my lord, he's enjoying. Now the school is deprived of that property. Now school is not functioning, my lord. I am as former student, earlier I moved to this court, my lord, in 2002, my letter petition. Where 2014, there is a direction to the collector, my lord. In again also there is a direction. Pursuant to direction, my lord, ignoring this 45 deed, my lord, collector passed an order, my lord. But my limited grievance, my lord, that instead of collector passing such order, collector would have been rectified such a mistake, or it would have been brought to the notice of the Board of Revenue for correction of the.
So what are you doing now?
Lordship,
What are you doing now? You were a student of that
that time,
grade school, but what are you doing now?
I am involved in other fields, my lord. I've explained in my
Fields are many.
lordship.
Fields are many. Why?
My personal, I am the ex-engineer, my lord. I am doing my independent business also.
Or
But- That's
where is the school situated?
in Digapandi, my lord, in the district of Ganjam.
Where do you live?
I am living in Berhampur now. This is more nearly, it is 30-40 kilometers highway.
What was that earlier PIL? Which has been disposed
yes.
of by this court.
Yes, OJC number 2383 of 2022, my lord. The order I have annexed, my lord. And annexure 8, my lord.
That means there's another one.
Another PL also 14523 of 2018. That is annexure 9. The most relevant order also, there is a specific direction by earlier PL, my lord. And para 6.
My lord, may I be
But in
permitted
your
to sum-
certificate, you have
Yeah.
given only one number.
No, 2 numbers I have given.
In your certificate, you have
If
given
that
only
is
one
pending,
number.
I have given another number which is pending. One.
Please look at your certificate, consolidated petition.
I'm afraid it appears that the PIL is frivolous.
Yeah.
The nature of relief which you are seeking. You have
In
given-
the law, my lord, I have, in the meantime, I was verifying the law, my lord, the Survey Settlement Act, my lord, that the, in any correction or in pursuant to any government properties, my lord, then my lord, government call it for the, it is 42, my lord, 42A of the Act, my lord, rules also provide revision. Collector might so much to revise the order, my lord.
No, no. My lord, may I be permitted to submit? What has happened?
Yes.
What has happened, my lord, a piece of land which according to the petitioner was originally the school property. But subsequently there was a litigation between one trust and the school or school authority. And your lordship may see page 50 annexure 6. The settlement officer in appellate jurisdiction has finally decided that the trust is the owner. Accordingly, the ROR is to be issued. This order is the basis of the issuance of record of right in favor of the trust. That is in as early as 1999. Now he says that this order is liable to be set aside and the property should be remitted back to the name of the school because that has not. So my responsible submission is that this order cannot be taken into consideration or cannot be set aside in a jurisdiction under the public interest. That is my responsible submission. So if at all he is aggrieved, he can take recourse to the filing of the proper application to challenge the order because it is already 25 years past. This order is still staring it in the, and apart from that, he is a third party to all these things.
And who is occupying the land?
The trust, no trust. Trust, not one case Surya who was not earlier to the trust, my lord, is one of the son of one of the member, my lord. Since 2000, after passing of this order, he is occupying.
Therefore, we are of the view that It's a frivolous public interest litigation.
My humble submission, Your
Your
Lordship,
humble submission, we can understand. You are seeking a direction that the entire income out of properties under Annexure 8 by following due process of law should be recovered.
that was pursuant to earlier direction, Your Lordship, under annexure by the Sonal Court, my lord.
All right.
Annexure 8, my lord. The matter would have been taken to this.
No, we will take up the matter.
Lordship.
We will take up. We will decide the matter.
I'm saying, my lord, my humble submission that the
No, we are
mayor
saying that we will decide your case.
decide how best.
Since the matter is there before us, don't we have the duty and right also to decide it? This way or that way? It is our function.
You're saying there's already an order on 17/10/2014 by this court.
Yes, Lordship.
So that order is there.
It has not been carried out, Your Lordship.
That is another PL.
Thereafter, another PL as well, the direction was to consider representation. On that representation, collected disposed of, but that order is not complied also.
Who is,
It is collector is not acted upon that order. It clearly is stated in para 6 of the order.
PL rules. ಅದೆಲ್ಲ High Court order.
Misuse of PIL. Was the intent of the right.
May I permit it to pursue before the competent authority? Your
No,
Lordship?
no, you are pursuing the matter.
Board will take it. May I permit it to withdraw the Lordship, withdraw the petition with the appropriate.
I didn't go.
That's why I request.
We will apply chapter 3 of the High Court rules. Yes.
Pardon? So I request to withdraw the with.
Have you examined chapter 3? No. Public interest.
I permitted to withdraw.
Don't do it again.
That's why I.
This application is just. Yes.
Item number 15. May I praise the Lord? You know, the petitioner's bid has been rejected, my lord. And I'm challenging the decision-making process being arbitrary and unreasonable, my lord. Here, under Annexure 1 at page 21, my lord, a tender call notice was issued to provide manpower services from the agencies. And pursuant to the said tender call notice under Annexure 1, the petitioner applied, submitted its bid, my lord, technical bid as well as financial bid, my lord. So on the date of, there's a condition at page 28, my lord, serial number 4.
Yes.
Here, one of the technical requirements, my lord, serial number 4, second column, valid address proof of the office, and which says copy of the electricity bill. There's a oblique mark, or rent agreement and copy of rent receipt, my lord. Here, the technical bid was opened. The petitioner, along with other representatives, were present on 27/6/2024. Thereafter, the financial bid was scheduled to be opened on 28th of August, June, madam. Here, on the opening date of opening of financial bid on the scheduled date, the petitioner has remained present. Madam, he was told that since he has not submitted the rent agreement, although there is no written communication, since he has not submitted the rent agreement, so his bid, technical bid cannot be accepted. Here, my lord, the petitioner had entered into an oral agreement, my lord, with the landlord of the property. He has submitted the electricity bill, my lord. The lordship will find at page 106, my lord, showing payment of the dues, and the name of the landlord as well as the address has been mentioned in the bill, my lord.
So where is the rejection?
The rejection is no written communication, my lord. They have selected the bidder, successful bidder,
No, one thing
in shape of
is,
lottery.
if there is no rent agreement,
Oral agreement.
no, oral agreement,
Right.
yes. And you'll give a electricity bill in somebody else's name. How
No.
will it be?
No, the petitioner has been operating his office over the scheduled premises, and the address is there, my lord. Lordship may kindly have a glance at page 106 to the bottom. I have been rendering services, manpower services to the university, my lord, and under Annexure 6 at page 110, they have intimated the petitioner that
See, did you submit copy of the rent receipt?
my rent receipt, my lord, I have submitted the copy of the electricity bill, my lord.
Electricity bill, anyone can submit.
Lost.
See, if we go by this, it
Well.
says valid proof of office.
My
Valid proof of office, how? Copy of the electricity bill.
or rent
Slash
is
rent
my
agreement.
lord.
And copy of the rent
My
receipt.
lord, it's assume that either copy of the bill or the rent agreement, and
Why? Copy
that's
of
a oblique
valid
mark,
address
my
of the
lord.
proof, copy of the electricity bill and copy of the rent receipt. If it is rented premises. If it is not, then nothing.
They say the copy of the electricity bill, oblique rent agreement, and copy of rent receipt.
Copy of rent.
So anyone can anyone meets the
Anyone,
requirement.
and there and copy of the rent.
And you'll have to that's
How
a
will it
oblique
connect?
mark.
How will it be connected to you unless you give the other document?
I have submitted. I have also
The
informed them.
electricity bill, you have informed.
Yeah. I have stated that in the REIT application also. And I have informed that
So how will the persons who you have giving the submitting the tender before know all this? You inform them orally.
they inform them orally at the time of opening of the bid. They inform the petitioner that you have not submitted the rent. That I have stated in the REIT application also, my lord. So technical bid was accepted. They didn't cancel my bid. They didn't intimate anything that the technical bid. This is one of the technical requirements in the tender call notice. I was allowed to participate in the financial bid, my lord. I have
Where is
stated,
your rent receipt?
my lord.
Where is your rent receipt?
I've submitted the bill, the receipt of the
No, this you have filed, now you have filed a writ petition.
my
In the writ petition, you must have stated that you are having an office.
my.
Where is the government?
Also, if you see paragraph 7 is 9. The petitioner being present on the scheduled date of opening of the financial bid has brought to the notice of the university that the petitioner has submitted the copy of the which clearly reflects the valid address which is located within the jurisdiction area of the university.
So even in the writ petition, you have not stated.
You know, so absolutely, which is located within the jurisdiction.
Look, no, how do you have the electricity bill in respect of that?
There is an address proof to the below
Address
the
proof,
minor
address proof of what?
of the
Address proof of
premises.
How do you connect yourself with that address? With that office, with that premise? Sorry.
My lord, Lordship may kindly consider, my lord, this is one of the technical requirements, my lord.
No,
There has been no
not-
cancellation of the technical bid.
It is highly unsafe to.
My lord, it's a very old manpower. Your lordship have filed the document to show, along with the technical bid, I have been rendering service to the university also.
Right.
And I was continuing till 31/3. Thereafter, the period was extended. Your lordship may kindly see Annexure 6 at page 110.
All right, we have understood.
I have been providing manpower service to the said university, my lord.
The petitioner claims to be a private limited company registered under the Companies Act 2013, carrying on the business of providing manpower and services of placement and other security services. So the present writ application has been filed, putting to challenge the action of the opposite parties in rejecting the petitioner's bid against tender call notice dated
12/6/2024.
12/6/2024. For where is that?
Annexure 1 at page 21.
The rejection been communicated to you?
No rejection. Abstain.
Well, once it is rejected, then you are, why this is premature?
They have selected a lottery was conducted. A lottery was conducted and I have made him a party also, well, the successful bid. But no agreement as on date has been executed.
For finding manpower to Khalipur Unitary University, Barhampur Ganja. Full stop. Next. The said tender call notice was issued on 12/6/2024. It is the petitioner's case that pursuant to the said notice, he had filed his technical and financial bid. So stop. clause 4 of the tendering requirements for the tendering, technical requirements for the tendering manpower service provider required a supporting document in support of valid address proof of the office of a tenderer in the nature of court copy of the electricity bill / rent agreement and copy of rent receipt, unquote. Stop. Next, the petitioner has asserted in the writ petition that he had furnished an electricity bill in support of the proof of office in terms of the said technical requirement. Stop. It has also been asserted in the writ petition that the when was that open? Paragraph 7.
Maluk,
We were reading paragraph 7.
Maluk, page 9.
That the financial bid of the petitioner was opened
Maluk,
in his presence by the university, and a clarification was sought from him as regards valid address proof. Stop. The petitioner is said to have informed the university that he had submitted a copy of the electricity bill which clearly reflected the valid address proof of the office located within the jurisdictional area of the university. Stop. Next. Learned counsel appearing on behalf of the petitioner has submitted that the petitioner was not required to submit any lease agreement or rent receipt because he had submitted the electricity bill. So stop. In response to the queries made by this court, learned counsel for the petitioner has not been able to convince that the petitioner had taken the said office on rent. So stop. Next, the fact remains that the work has been awarded in favor of
opposite party number 3, Maluk.
opposite party number 3. So stop. What is your case? You were the lowest or highest?
That they have not displayed.
The petitioner, it is not the petitioner's case that his financial bid was lower than opposite party number
3 months.
opposite party number 3. Now, there is no document there is no material to demonstrate that the petitioner's bid was rejected on the ground of insufficiency of proof of evidence, address. So stop. In any case, we are of the view that merely submission of an electricity bill without even a rent receipt, comma, the petitioner was not able to support the to give valid proof of address. Oh. We are not inclined in the present set of facts and circumstances, we are not inclined to interfere. This application is accordingly dismissed.
Item 16.
May leadership. And here simply inaction of the opposite parties. And after completion of tender and being declared a successful lordship, bidder petition declared successful, and after issuance of letter of acceptance, lordship state I come to Annexure 4 lordship, page 69.
Yes.
Lordship, here lordship on 16/3/2024, lordship, the tender voted on 5/1/2024 with a promise to complete the work within 14 calendar months, lordship. I declared a successful bidder, and on 16/3/2024, as per the terms of the contract, they issued me letter of acceptance, lordship, with certain terms and conditions. And lordship, in view of the terms and condition, I deposit the entire 3 crores, lordship, more than 58 lakhs with them. And till date, lordship, they are not acting upon lordship any manner, though there is penal provisions are there under the Objection code, but they are not issuing the lordship work order or lordship. They are not issuing work order or executing agreement with me, lordship. That is.
What penal provisions?
Lordship, kindly see.
No, tell us.
Lordship.
What are the penal provisions?
Penal provisions, lordship, on the Objection code, and as per the agreement, if I will not complete the work.
First, after you are awarded, you will complete.
No, lordship. Lordship, kindly see Annexure 4 for a moment. They have issued, lordship, letter of acceptance on 16/3/2024.
Yes.
Then, lordship, kindly come to page 42 for a moment.
No, page 70 is in case of default on your part.
No, page 42, lordship, kindly see. Page 42 of the brief. That is clause 34.6, lordship, Roman 6, lordship.
Yes.
Page 42. Before acceptance of tender, the successful bidder will be required to submit work program and milestone basing on the financial achievement so as to complete the work within the stipulated time, and in case of failure on the part of the agency to achieve the milestone, liquidated damage will be imposed. That's one punishment. Then lordship, kindly come to
Mr. Dole.
There is no failure on your part, you are successful.
But lordship, I have given work program. But letter, lordship, can say Annexure 4, pursuant to this letter of acceptance, I want to do, lordship, did 2 things, lordship. First, lordship, I deposited 3 crores 50 lakhs as per their demand, lordship. Then I also produced the work program. Lordship, kindly see the condition itself speaks up, lordship.
So what is your grievance? You are scared of punishment, or
lordship,
you are aggrieved?
I have lordship invested crores of rupees and all my man and machineries, lordship, waiting for this work, lordship. And now, lordship, this in the by this time 4 months has already been elapsed.
Yes. File your application. Why is it happening?
You should take instructions.
3 weeks. As it. Yes.
Lordship.
Item 17.
Yesterday's matter, Lordship directed my friend to take instruction whether suspension provision is there or not. I have verified there is no such provision.
My lord, there is provision, my lord. Pursuant to lordship directions, I have already sought for the instruction. I have already obtained from the Tahsildar, my lord. Yeah. Lordship, kindly see page 2, my lord, of this instruction, my lord. Page 2,
Since
paragraph
you are
3,
relying on
Roman.
the instruction, then it means that there is no provision under the rule.
No, that is the provision, my lord. I'll show, my lord. Lordship, kindly see for a moment, paragraph 3, Roman I, my lord.
Yes.
The lessee Sri Manas Kumar Barik has illegally and unlawfully trespassed and crossed the leasehold area of 1912 square meters and excavated the sand at the depth of 2 meters. The volume of illegal and unlawful excavation made by the lessee outside the leasehold area is 3824 cubic meters, which is violating such and such. Well, Lordship may kindly see rule 51.4 for a moment. OMC rules, my lord, 51.4.
Even 4.
51.4, my lord. Lordship got it?
Yes.
Whenever the person wins without any lawful authority any mineral from any land,
Sorry, Odisha Minor Minerals Concession Rules 2016.
my lord,
You are referring to 51.
rule 51.4, my lord.
51.
4, my
51 is penalty as a 4.
my lord.
Right.
Whenever the person wins without any lawful authority any mineral from any land, the Tahsildar or the mining officer or the deputy director or divisional forest officer, as
What
the
is
case may.
lease?
Let's see.
Probably there is WAEN must be that. Excavate some.
Yes.
A forest officer, as the case may be, may recover from such person the mineral so won, or where such mineral has already been disposed of, the price thereof, and may also recover from such person rent, royalty, or tax, as the case may be, for the period during which the land was occupied by such person without any lawful authority. Lordship, for kindly see, my lord, 57.2, my lord, for a moment. 57.2, my lord. 57 is the power of entry and inspection. 2, my lord. The director or any officer authorized by him shall have the power to inspect any area held under a prospective license, mining lease or a quarry lease, so as to ensure systematic, scientific, and safe prospective operation or mining operation. And Lordship, kindly see 3. In case any deficiency is observed as a result of inspection conducted as per sub-rule 2, the lessee shall be intimated not
You are
to carry out.
what?
Lordship,
7.3.
57.3, my lord.
7.3 is any mineral tool equipment.
My lord. In case any deficiency is observed as a result of inspection conducted as per sub-rule 2, the lessee shall be intimated not to carry out any operation in the area under the lease unless the deficiencies are made out, which shall be brought to the notice of the competent authority, controlling authority, or the director, as the case may be, by the inspecting officer.
That is all right, but you have not yet intimated him as per 57.3.
57.3, my lord, because we will write shortly because there are some inquiry. And my instruction inquiry is already over, so we will shortly going to be informing.
Yes, 57.3 is there.
My lord, the 57, 51.7, your lordship, for a minute.
Yeah.
In case of breach of any condition of the lease deed, the competent authority may give notice of 60 days to the lessee to rectify the defects within the time specified. And if the lessee fail to rectify the defect within the specified time, the competent authority may cancel the lease and or levy penalty and exceeding rupees 50,000 sols. There is penal provision. If I have violated anything,
They have to take action as per 51(7).
They will take action under 51(7) also. Presently, they have stopped you.
There is no provision.
57(3). 57(3) is there.
My lord, 57(3) is not authorizing them to suspend the work.
That is what the meaning was. That is the meaning of suspension.
Your lordship, I am placing again.
Not to carry out any operation, that is suspension.
In any case,
Suspension. What is the effect of suspension?
my lord,
Suspension means in limbo.
there is, my lord, your lordship may kindly have a glance to the impugned order under Annexure 10, your lordship.
Yes.
By invoking the power under 51(1), 51(4), 51(7), they passed this order.
That is
They cannot supplement or supplant any.
no. That is, they cannot supplement or supplant. You are right. But if wrong statutory provision has been mentioned, that will not render an order illegal.
That
So only because of that, if they have the power and if they have exercised, there is nothing wrong in it.
here, my lord.
How much time will you take? So have you filed your affidavit?
No, my lord, this is first time, my lord. Within 10 days, we'll give him the,
File affidavit.
my lord.
Do it fast because either way you have to give him a
My
chance
lord,
to rectify.
within
it.
10 days.
The rainwater will come within a week or two. Let me operate under their supervision.
See, we are not disbelieving you.
My lord.
And at the same time, we can't disbelieve them also.
My lord, my learned friend is taking instruction from the Tahsildar.
No,
This-
mining officer, sorry.
You have given this from the Tahsildar?
No, mining
sir.
officer.
No,
You have not
disbelief,
done it.
when we say disbelief, we'll say that once the counter affidavit is filed, there is no question of believing or disbelieving based on the instructions which he has received.
Obliged.
You are making submissions on the basis of your the government's made in the reputation. They will take stand on the basis of what they say in the counter affidavit. Then the question is would arise, we are believing. Believing you means believing your client, not your counsel.
They have a web portal. They have installed a camera. They are supervising it. This sandbed was vacant for quite a long period.
There are police stations.
Yes.
There are the whole hierarchy of police, and then CBI, and then IB, and then what not. But still, the crimes are being committed because they are smarter.
My humble submission, because the period will not be extended.
We will see if that is if finally you succeed.
Ma'am.
We'll give you appropriate relief.
Rainy season will come now.
Or
I have invested a huge amount.
unilateral orders cannot be passed. 2 weeks time is allowed for the opposite parties to file counter affidavit. Let's this case 2 weeks.
Item number 21.
Obliged.
The report expects
May I
that a
please?
copy of the counter affidavit served on learned counsel for the petitioner well in advance,
My lord.
at least 3 days before the present matter has been directed to.
My lord. Obliged.
Item 21.
May I please, my lord? My lord, in this petition, challenging basically one provision of the recruitment rule of 2013, your lordship, which has been already amended in the year 2024, your lordship. Only its application needs to be in our case. In the similar case, your lordships had observed that the amendment being in clarificatory nature should be applicable to the main order, your lordship.
So it has become what?
That because they have, even after that, they have rejected, saying that it is prospective, not retrospective.
So what do you want?
An order of your lordships in the light of the previous order, because the same.
What is that previous order?
My lord, the problem was there are two cadres, your lordship. Group A cadre, Group B cadre. There are one anomaly in both the service condition rules, that the training period will not be counted towards service and they will not be paid salaries for that period. They amended that duly. For that we had challenged and they amended that subsequently.
But they are saying that it is prospective in nature, not to be applicable to the, and we have all, your lordship has already held.
Where is that order?
My lord. In Annexure 14, your lordship, 67 to 70. Same anomaly existed, and your lordship had held that the apprehension is that it may not be applicable to the recruits to the previous year, and your lordship had. Page number 70. We dispose of the writ application with an observation that the petitioner shall be entitled to the benefits arising out of the amendment of Rule 15.
So same thing.
My lord, in this case, it would be Rule 13.
Rule 13.
My lord.
Of which rule?
2013 rule.
Same rule.
My lord, rule of the year 2013, rule is also 13 rule. Rule 13.
Instead of Rule 15, Rule 13.
Yes, instead of Rule 15, here it would be Rule 13.
And you have challenged Rule 13.
My lord. Page 64, they have amended it.
So if you substituted Rule 13,
My lord.
Rule 15 by Rule 13, will it serve the purpose?
No, my lord. That Rule 13 has been amended. They have amended, while your lordship may kindly look at page number 62. This amendment is to be applicable to the case of the petitioners.
So same thing.
My lord.
In view of the amendment,
My
in
lord.
view of said Rule 2024,
My lord.
and counsel for the petitioner. In the present rate application, Rule 13 of Visa Forest Service Group B.
Group A.
Group A.
My lord.
Directed Recruitment and Condition of Service Rules 2013 is under challenge. So stop. Under the said rule, officers of the said group are required to undergo training for a period of
2 years.
2 years
My lord.
instead of 18 months.
In their case, it was 18 months. In our case, it's
2 years in Forest College.
My lord. Forest institutions.
Forest institution.
My lord.
To obtain which qualification?
Diploma in forestry. It's basically forest training academies actually. That is government, central government forest
Diploma
training.
in forestry. So stop. The virus of the said rule has been put to challenge only to the extent that it provides provided for grant of stipend only in place of salary for the period of training. And also the effect of Subrule 4. Subrule 4.
No, my lord. Subrule 3A, B, C.
No, that thing. Computation of period of service.
My lord. That is Subrule 2.
Subrule 2.
Your lordship may kindly come to page number 40, it would be clear. The rule that is under challenge.
No, you have had two grievances in that case, that you are not getting salary, you are getting a stipend, and two, that period was not computed
My lord.
as period of
My
service.
lord. That is under Rule 13, Subrule 3. During the training period, Subrule 2 is during the training period, selected candidates shall be granted each a stipend, as may be fixed by the government from time to time. This has been deleted by them. This has been amended at page number 62, your lordship.
Lord, here there is no challenge to the rule. Here there is no challenge to any rule. In fact, in terms of the pre-amended rule, they undergone training, and for that period they have already received the stipend. So the provisions of the statute has been worked out. Now, the new rule which came into force, that is the amendment rule.
No, whether he is relying on an order of this court, 6/5/2024. Have you seen that?
Yes, my lord.
So whether his case is covered by, the circumstance is similar or different?
My lord, in that case, as I have understood, my lord, in that case, the proceedings were pending before this honorable court, and the amendment came at that point of time, and it was produced before the honorable court. So the honorable court directed that their apprehension of not being considered under the new rules not be there. But here, in the present case, as per the pre-amended rule, that rule 13, they have undergone the training because they are the recruitee of 2015-16, and the rule came into force in 2013. So they have already undergone the training, and for that period, they have already received the stipend that was fixed for that period. And the provision of the rule, that is rule 13, has already been worked out. Now, my lord, so far as the amendment rule is concerned, that amendment rule that bears a specific provision that the said rule comes into force from the date of its publication in the Gazette. So this amendment rule can be made applicable to all prospective appointments, not to the case of the petitioners who have already received the benefits.
Yes, he appears to be.
My lord, the case is squarely and fairly covered by your lordship's judgment. The similar provision was there in our cadre rule and in the cadre rule that your lordship.
That is not the question. The
My
question is that here
My,
you were undergoing training
my lord,
in the case which has been decided by us,
my lord,
on which you are relying on.
my lord.
And in the present case, the impression which we are gathering on the basis of what he is conducting, that you had undergone training long back,
My lord.
and now you are saying that
No.
$50 type.
That is that I will clarify. In the year 2018, we joined, and when we came to know that in the advertisement there was no provision of stipend. The advertisement said that we will be getting the salary. When we didn't get the salary, we instantly lost the tribunal, and this honorable court asked started with the tribunal. Then that case came as a transfer.
File your affidavit.
My lord, my lord,
Let him file it.
my lord.
Four weeks.
From 22.
Kindly see your lordship's last order on 26/2024. Lordship granted last opportunity to comply the order.
The petitioner has been called upon to produce the mark sheet so that a decision can be taken. He will be given the benefit that is not in your lordship's order because it has been also confirmed in the Honorable Supreme Court. Now he has been asked to produce his original mark sheet for verification only. Once he produces that mark sheet, the benefit shall be given. Letter has been issued on 10th of July. If my friend can also ask me, I am giving a copy to him. If he can instruct us, we will verify it and thereafter we will comply the order.
Monday.
Item 23.
23, I already filed the compliance affidavit. Also giving copy to my friend also.
Item 24.
Is not, the order has not been complied, according to petitioner. So your lordship may observe, any, there is a related to the refuse, your lordship has direct the petition to take a decision as per the Raghunath Sahu case. And after providing opportunity of hearing, there is a order is wrong, so that,
The petitioner will have the liberty to question the correctness of the decision.
No. So we can get liberty to challenge me also if there is no problem. I filed, we have taken a decision, filed that compliance affidavit that we have already taken a decision, communicated them. He is not satisfied. He can challenge
Yes,
it.
that
No
is
problem.
what,
Yes.
Correctness of the decision taken pursuant to this court's order, violation of which has been erased in the present contempt application. Before appropriate forum in accordance with law. Yes.
24.
Your Lordship, in the present contempt matter, the operative part of the judgment, Your Lordship, is page number 89.
Compliant or not?
Not complied, Your Lordship.
When
And it
was
should-
the order passed?
Your Lordship, page 89, para 81, Your Lordship. Point 2.
Para?
Para 81, Your Lordship. Point 2.
Yes.
Your Lordship, as the petitioner has joined, appointed prior to 1 January 2005, his service is entitled as like a government employee and is entitled for all the pensionary benefits, Your Lordship.
Hmm?
Mr. Samantray,
No,
Item
it's Kotak Development Authority, because here you don't appear.
okay.
I cannot appear if Lordship may issue.
But there's a compliance affidavit? Item, sorry,
24.
okay, okay.
Or Mr. Mahapatra can appear, Dayananda Mahapatra may appear, Lordship, my friend serves a copy upon him, he may appear.
Yes.
Item 25.
Lordship, here I have gone through, Lordship, it's a second contempt. For the first time it has been listed because it was, even though it's a very old Lord's case, but it was recently dismissed by the Honorable Supreme Court. Now I will take instruction whether the order has been complied. If not complied, we will do it. Benefits.
Not yet complete, because
No, I will definitely, after dismissal, recently only it has been dismissed, Lord, in April 2024, I think, Lord.
Yes. 15-4,
15-4. So we'll comply, Lord, because this order was challenged by us in the Supreme Court.
As requested on behalf of the contenders, this matter on 6 weeks.
What orders?
Planet AGA to report full compliance of this court order. Violation of which has been erased in the present contempt application. Yes.
Item 26.
Hey, this person, I think, I remember the name. Why is the name very familiar?
Amendment 10, 2012. No. This application has been filed here. IE number 1010. Right. Mister, we will have to give you an opportunity. Why your objection?
Bail.
Yes, who is this bail?
Application for bail, Lord.
Yes. So you file an objection. required.
If objections, my lord, so we don't, normally we don't file any written objection.
Normally, that is the mandate.
My lord.
That is
If
the
you also, I
mandate.
can only argue, but if you also satisfied,
Please see, let us go by law.
the amended act, my lord. This amended act,
No.
old act, my lord.
That is the provision.
No, my lord, but he is already.
Just see, let us be clear on law. The appellant upon conviction for the offences punishable under section 449. Number one. Yeah.
Because 1010/2024 says appellant one, but again it says.
Appellant number one. Appellant number one. Upon his conviction for the offence punishable under section 449 and 2 read with 34 of the IPC has been sentenced to undergo imprisonment for life. First off, this application has been filed for suspension of sentence and release of the appellant number one on bail under section 389 bracketed 1 of the CRPC. Mainly on the ground that he has remained in custody continuously since the date of his arrest on 11/10/2012. That's all. Next, on the ground of the petitioner's period of incarceration of appellant number one, and there is no likelihood of the appeal being taken up for final hearing in near future, we are inclined to suspend the sentence. So next, however, in view of the proviso to subsection 389 bracketed 1 of the CRPC, let objection, if any, be filed on behalf of the estate by 1 week. Objection, if any. Objection, objection, if any. Objection, if any. Did you see that?
Yes, 318(1) says that the opportunities of filing objections should be given to the public prosecutor. That is
So
there.
this is the opportunity which we are giving.
So I will give, not only instead of 7 days, can you also grant, please to grant me 10 days? Because the IAC has to come and file that affidavit.
All right, 10 days.
Because it's a conviction matter.
10 days.
Right.
Be taken up as the first case. First case for orders.
Item 27.
In item 27, I am for the appellant, my lord. Mr. Sahu, who was in the court appearing for us, left now because he did not feel well. So he requested me to make an adjournment on his behalf.
Yeah. As requested on behalf of the
My lord, here I am for the appellant, my lord.
respondent, we are doing the respondent. Takes this matter on. When
After 1 week,
we
Item 28.
I am for the respondent. On 9/5 order, your lordship kindly have a glance. Neither the notary copy of the appeal petition nor the IA for conversation delay has been served on us. So we are unable to file the objection.
why give him? Why have you not given?
Saving statement. I'll give it today. Today.
Let copy of the application seeking condonation of delay and in memo of appeal be served upon and counsel for the respondent in course of the day.
In course of.
In course of the day, let's this matter on 1 week.
There is some noting on the file that allowed by common order dated 11/5/2023.
This matter was not linked to that batch,
That batch
but
is-
somehow it was erroneously listed and disposed of.
And that is
Basically,
Again.
a recall
recall.
petition filed by the
All-
respondent, so
all
that
right.
the order has been
All
recalled
right,
and restored.
all right.
Yes.
Item 28,
After
sorry, 29.
2 weeks after.
Item 29.
Item 29, same prayer in item 27. Item
29 also you haven't served copy.
No, copy not served. In 27, that cases how was in 27.
So that is connected.
No, he is also in 29. He
Okay,
left the
okay.
court because of.
Lord, may I please, my lord?
Okay.
Lord, I am appearing for in the sub-item number 2, sub-item number 2 of item 29, appearing for the respondents. Lord, they have not served a copy of the memo of appeal or the copy of the application for limitation.
You have not filed your appearance memo, so on whom will they serve?
Lord, there is a name in the
Where?
list.
Where? What is
And
your
this
name?
Mahendra Kumar Mahapatra. And
Sub item 2, there is no name.
that is writ appeal number 1285.
That is the third one.
Third one. We pardon.
You are not Mr. Mahapatra. You are
A. Acharya.
A. Acharya. Okay. So this is related to item 27.
29.
29.
No, this is 29, but you are saying that Mr.
I was saying that Mr. Sahu was in 27. He requested me because of.
Oh, so it has to be adjourned, but not necessary that it is a connected case.
Not connected.
All right, all right.
Yes, he is also appearing in that 29.
18/7. Will be taken up on 18/7 because the first appeal, Mr. Sahu is not well. He had asked for an.
I am.
So let them serve a copy of the limitation application.
I am serving copy just now. You'll also may call this matter next week.
What about the second one?
Second one, no one has appeared.
All right, all right. 29, first item, right? List prayer for adjournment has been made on behalf of
Krishna Chandra Sahu.
on behalf of Mr. Krishna Chandra Sahu, learned counsel appearing on behalf of the respondent. List the case on
18/7.
18/7/2024 along with the connected cases. WA number 1285 of 2022. List the case on 18/7/2024. In the meanwhile, Mr. M.K. Khuntia, learned additional government advocate, shall serve copy of the IA for condemnation of delay on Mr. A. Acharya, who is appearing on behalf of respondent number 1.
I'll serve in course of the day.
Yes.
Obliged.
Item 30.
My lord, I am appearing for a respondent. I have filed objection to the delay petition day before yesterday. That might have not come to my lord's record.
How many days delay?
131 days delay.
Within time.
A similar matter, this honorable court also dismissed after 120 days delay in many cases. In many cases,
Many cases dismissed, many cases allowed.
therefore judicial discipline should be maintained.
Judicial discipline should be maintained by following the case where delay has been dismissed.
As per Supreme Court decision,
Yes.
Supreme Court decision, 3 judges bench and constitutional bench.
Yes, please give that.
State of Tripura to refer to the larger bench decision. Para 4 million.
So by which order the same matter has been dismissed?
My lord, what I humble submit, my lord. Main case writ petition prayer was during the pendency of the criminal case. Whether the respondent, I am appealing for respondent has a right for consideration for promotion.
That has been decided.
That has been rejected, your lordship. Therefore, Honorable Supreme Court, 3 judges bench and 5 judges constitutional bench has held that the matter should be referred to the larger bench. Instead of same coordinated bench, same strength, should not pass the order deviating the order passed by the same coordinate bench earlier.
Has that happened?
My lord,
Has this happened?
has it happened? Your lordship earlier order did not refer to the larger bench, saying that this is not required, my lord.
No, that is, you are right, that is judicial indiscipline, but has that been done?
In another
Have
case,
we differed? Have we taken a different view than the view taken by a coordinate bench?
my lord,
Where is that?
they are relying the decision.
Yes, Mr. Kutil?
No, your lordship has taken into account all the judgments that your lordship has seen that I have relied that judgment. Last again, and I have also annexed my appeal, my lord.
And you should be careful. If you are saying what you are saying, if that is correct,
Lordship kindly.
then we will
So,
surely.
my humble submission, this is my humble submission before your lordship. Your lordship will decide finally.
Yes, you cannot. You cannot decide.
Only I'll place my lord, the facts.
So what are you showing?
In the earlier case, my lord, two division benches directed for a concession promotion on ad hoc basis.
Just a minute, just a minute. Devi Prasad Nanda.
Okay.
Yes, so this is the order.
Your lordship did not refer to the larger bench.
We did not refer to the larger bench because
My
that decision was not taken into account.
No, your lordship taken into account that judgment, but saying that what honorable
Because
Supreme Court
earlier
has.
decision was not taken into account in case of Bari.
My lord,
Yes,
I am placing the Supreme Court judgment, your lordship.
yes.
That I am reading that Tripura Bar Association and others. Yes, para 4, your lordship kindly see. The 3 judges bench of honorable Supreme Court. We are of the view that division bench of the High Court, which has delivered the impugned judgment being a coordinated bench, would not have taken a view different from that.
All right. All right. You can challenge that.
And constitutional bench judgment, if lordship.
All right, we will see when we consider the merit.
My lord.
We may change our view.
My lord.
Because based on your- which item?
Item 30.
30. IA 5058, 2024, dispensing with filing of certified copy. That's the legal order. Filing of certified copy is dispensed with, IA allowed and disposed of. IA 5059 of 2023. This IA has been filed for condonation of delay of 132 days and filing the writ appeal. Where is your objection? This one?
Objection I have filed, perhaps that is not in the record. Perhaps you will also kindly verify the records. My lord. I have objection filed day before yesterday.
We have heard Mr. M.K. Khuntia, learned additional government advocate, and Dr. J.K. Lenka, learned counsel, appearing on behalf of the respondent. considering the reason stated in the IA for condoning the delay in filing the written appeal, and as the delay concern is only 132 days, in spite of the objection of Dr. J.K. Lenka, learned counsel appearing on behalf of the respondent, we are convinced that it is a fit case for condoning the delay in filing the writ appeal. We are convinced that it is a fit case for condoning the delay in filing the writ appeal in the interest of justice. For condoning the delay in the interest of justice, we allow the IA and condone the delay in filing. Condone the delay. The IA is accordingly allowed and disposed of. The writ appeal lists the case on 18/7. No, list the case on 25/7/2024 for fresh admission.
Item 45, on my mention, my lord, item 45 was listed today. Yesterday, I mentioned some urgency. Yesterday, I made a mention. The lordship has put this matter on board, item 45. Maybe let's say about that demand of additional performance security after the tender has been awarded by wrong interpretation of a clause of the tender document. May I please, my lord, that since it doesn't read today, may I please tomorrow?
Tomorrow, it will come on Monday.
Monday, my lord, they may determine.
Tomorrow, a bench will have to be constituted for this case.
Lordship.
Why is the matter so urgent that it cannot be taken up on Monday?
But after issuance of notice, they have communicated me that they will determine the contract, the bid by forfeiting my security. Right. What happened here, my lord, in the notice inviting tender, there was two identical clause for performance security. Once I became successful and the LOI has been given to me, I have paid the performance security as per the contract. And there is an upper capping to that also. But they now interpret another clause, same performance security, and its number is same, everything. So I'm asking me to deposit another higher value of performance security. So I made a representation to them, saying that these two clauses on the NIT are apparently divergent, and therefore, because of this ambiguity, it's required to be resolved in terms of the contract. There are certain provisions in the contract which say, instead of that, they.
Well, you could have said something in the morning. Now what is it done?
Well, that's correct.
When you mentioned, you should have mentioned in the first.
I hope that the last item in the was face admission.
All right, tell us in the Monday.
Monday
the matter will be there.
Millard, I may be excused, Millard. I'm appearing through VC Millard. Item 56. I want to withdraw the writ appeal. I'm filing memo to that effect.
Yeah.
Monday,
could it be on?
Monday will take up.
Lordship, item 60,
Just
the interim order.
in the morning.
Item 60, my lord, the interim order is still today.
All right.
Sub item, my lord. Item 60, sub item, my lord.
Sub item, then other matters also must be having
No,
order.
in the first case, there is no interim order, but second case is mine.
What is the number?
WPC 906 of 24.
Bas.